Hello, everyone. My name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. Thank you for participating in this legal resource panel case law update. ECHO is a statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now presented on the screen. We have a large number of attendees today, which usually means a lot of questions. We will do our best to answer them. Please use the Q&A icon, not the chat icon, to ask your questions or make comments. You should use the chat icon to report technical issues and to communicate directly with other participants in the webinar. You will find the navigation icons by hovering over the bar at the bottom of the page. I will respond in writing to some questions in the Q&A feature during the presentation. Please keep your questions general in nature. Questions about specific situations are better asked one-on-one. To help us select the most relevant questions for the audience, please use the thumbs up icon found on the Q&A screen at the bottom of the left corner. Simply click this upvote icon and select your favorite question. And now for our disclaimer, which you'll also find on the screen. None of what is said during this seminar shall be construed as specific legal advice from the speakers, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney. Thank you. And now on with the program. Our webinar today is the Legal Resource Panel Case Law Update, featuring Mark Wielinski, Esquire. Mark serves as General Counsel to community associations for day-to-day activities, including Davis Sterling, interpreting governing document, reviewing proposed contracts, and resolving owner disputes. He also works on claims for construction defects, budget shortfalls, and insurance coverage. Mark has focused on community associations since 1980, starting his own law firm in 1986. Mark, please go ahead.
Thank you very much, David. Good morning, good afternoon, everyone, and welcome to the ECHO Legal Resource Panel. My name is Mark Wielinski. I'm the chair of the panel. Today, we're going to go over new decisions from the California Courts of Appeal. We're also going to talk about verdicts and settlements in the trial court. Generally, during the past 5 or 6 months since our last legal resource panel meeting. You might think that the courts and the legislature have been not so active recently. I assure you, they are working hard to make your life complicated. What is your best defense? What's the best thing you can do? The answer is education, to learn what's happening and how to deal with it. ECHO is a main source and way for you to keep current with these kinds of events. So I think we all owe a great thank you and round of virtual applause to David and Connor Zapponi and everyone at ECHO for all their work in helping you do your job. Today, we're going to be working from PowerPoint slides. So I would ask we move to the next slide, listing the topics we're going to be talking about today. 6 cases from the Courts of Appeal and more verdicts and settlements from the trial courts throughout the state of California. The cases we're going to be talking about from the Court of Appeal include restrictions on a licensed contractor and recent developments on how those might be changing. The second one, governing documents call for equal and uniform assessments. This case says it goes to the method of computing assessments, not the amount imposed being the same for everybody. The third case will talk about trees obstructing views and the idea of litigation to regain tree views in the courts. Next, we're going to talk about noise nuisance. If they meet the requirements of a local code, does that mean they're immune? No. We'll discuss that. Then fifth, another case in a long line of short-term rentals. VRBO, Airbnb, are they prohibited? What can you do? Finally, the last case we're going to talk about, settlement discussions. Every homeowner association has claims and gets hit with claims and wants to discuss settlement. When do settlement discussions turn into extortion? We'll talk about that in a recent case. Then we're going to discuss the courts of appeal, the trial courts, verdicts, and settlements. We'll go from a $39 million jury verdict for internet impersonation all the way through to defense results where the plaintiff gets nothing. Let's get going. Slide 1, Pantera GP Inc. versus Superior Court. This case concerns licensed contractors. The rules in California are very strict. Let's talk about the rules first. In California, if you do work that requires a contractor license and you don't have a license at all times during your work, basically two things happen. It's under the Business and Professions Code 7031. First, an unlicensed contractor cannot collect a penny for any labor or any materials, even if there's absolutely nothing wrong with the labor or materials. Can't collect a thing. Secondly, if the unlicensed contractor has received compensation, the owner can sue to get it back, all of it. Those rules are very important in the case of Pantera GP Inc. versus Superior Court. The facts of this case are a little bit complicated, but very instructive. Pantera GP Inc., the corporation, Inc., is a licensed contractor. And yes, contractor licenses can go to a corporation, an individual, a partnership, or other entity. In this case, the license was in the name of the corporation. But Pantera had an affiliated organization that did not have a contractor license. That's Pantera Development, LLC, Limited Liability Company. The owner was Rosedale, Bakersfield, Retail, etc., that owned a restaurant in Bakersfield at a movie theater. The owners wanted to hire a general contractor for improvements. The owners prepared an AIA form construction contract. That's prepared by the American Institute of Architects. Fill in the blank. The owner did fill in the blank. But for the contractor, they named the unlicensed LLC as the contractor. Things went forward. The contractor provided $2.6 million worth of labor and materials. Guess what? The owner wouldn't pay. So, mechanics lien time. But the mechanics lien was prepared and recorded by the unlicensed LLC who was named in the contract. Footnote, the general contractor is the general partner of the LLC. Still, it's a separate entity. The owner sees the mechanics lien and prepares a mechanics lien release bond naming the unlicensed LLC. Everything's a stalemate. Now the contractor wants his 2.6 million, so he files suit in court. Only by this time, the contractor realizes the wrong name is in the contract. So the contractor with the license is the named plaintiff, Pantera GP Inc., the licensed contractor. Trial court, case dismissed, amended complaint, third amended complaint. The plaintiff is still the licensed corporation, but now the complaint asks for equitable reformation, asks the court to change around the contract so that the party on the contract is the licensed corporation, not the unlicensed LLC. Trial court, you can't do that. You can't change the contract that way. Case dismissed, owner wins, contractor gets nothing, demur sustained. Trial court says equitable theories like reformation of the contract to change the name of the party, we're not going to do that under 7031, no equitable relief for an unlicensed contractor. Court of Appeal, reversed. This is very unusual. The Court of Appeal says the complaint alleges all parties agreed and intended, knew, and agreed that the general contractor would be doing the work, not the unlicensed LLC. And therefore, the contractor should have the right to ask the trial court to reform the contract. But there was a dissent. One judge in the Court of Appeal dissented and said, you can't do that. First of all, the mechanics lien is filed, recorded under penalty of perjury. And under penalty of perjury, the unlicensed LLC said they did the work and needed the money. The lien release bond also went to the unlicensed LLC. Furthermore, the contract attached to the complaint filed by the LLC, the complaint filed by the licensed contractor has an exhibit. The exhibit is the contract. The contract is in the name of the unlicensed LLC. So the general rule is that an exhibit to a complaint supersedes claims to the contrary in the complaint, says the dissent. So where is this going? The case is now going back to the trial court to see what the proof will reveal. All the owner, Bakersfield Retail, has to do is agree they really intended to hire the licensed contractor and they're happy to pay the 2.6 million. You think they're going to say that? You might say, Mark, how are we ever supposed to know if a contractor is licensed? They're not going to tell us. The answer is, it's easy. I can show you how to do this in 30 seconds or less. Next slide, please. there is a website, www.Contractor State License Board, CSLB.ca.gov. When you open up that website, here's the slide you get. On the left side, all you have to do is click on license check. Then you get the little screen in the middle is the next slide, and you can check a contractor license by license number, business name, or personnel name. The easiest way is ask the contractor, what's your license number? If you get any ambiguity from the contractor about what is the license number, you know you got a problem already. Once you put in the license number, the next thing you will see on the CSLB website is the name and address of the contractor, the license number, whether or not it is active and in good standing, what kind of licenses it has, B license, A license, specialty license, it'll be there. And as we'll see later on, really important, it'll tell you if the contractor has workers' compensation insurance. Really important. So there's a lot you can do. And the lesson of the Pantera case is always check to make sure the person you hire to do contractor work has a license, it is active and in good standing, and the company on the license is the same company as on your contract. You might think it's rare, but it's not. Frequently, a corporation holds a license. The president decides he needs a little extra money on the side. So the president will sign a contract in his own name using the corporate license. That won't work. You can't loan your license. Or vice versa. The president owns the license, but he's going to have the corporation enter this contract with the license in the name of the individual president. Sorry, that doesn't work. You're going to be in court, going to the Court of Appeal, asking for reformation. It's a mess. Don't even go there. Next slide, please. Lefleur versus Trabuco Highlands. There was a lot of internet buzz about this case. And basically what it said is lots and lots of associations have governing documents that call for assessments to be imposed equally and uniformly. In Lefleur, an owner bought a unit in 2013. Before that, the association, 819 units in 6 phases, had adopted a formula for the association so that assessments are computed on the basis of costs per square foot for landscape slopes, fire abatement zones, common area amenities, so that they would be imposed equally based on the cost, not an exact same amount per lot. The plaintiff read the CC&Rs and said, wait a minute, equally and uniformly, that means I should be paying exactly the same as everybody else, exactly. But I'm paying them 166, not 104. So the plaintiff stops paying and files a lawsuit for declaratory relief that the assessments are void because they are not exactly the same for every unit. Trial court, defendant HOA wins. In a summary judgment motion, the court said a single method of assessments, the same for every unit, is not a violation of the CC&Rs because the assessments were made in a uniform way according to the benefit each member receives in each phase. Court of Appeal, affirm. The CC&Rs that call for equal and uniform require their assessments imposed equally and uniformly, not in the exact same amount. Here, says the Court of Appeal, there is no evidence that assessment calculation was unequal. The plaintiff's demand for the exact amount of assessments for each property is incorrect, according to the Court of Appeal. So when you are calculating your assessments, if your governing documents call for equally and uniform, please be sure the method of calculating assessments is the same for each unit, even though the exact amount may not be the same. That's the lesson of the Lefleur case. Next slide. Con versus Price. Trees obstructing a view. This case concerns two adjoining properties in San Francisco. The uphill property has unobstructed views of the San Francisco Bay, Golden Gate Bridge, Angel Island, and Marin County from three different floors of the residence. The downhill owner plants a Monterey pine tree at the fence line. In 2001, plaintiff Khan replaces the fence and notices the pine tree is growing, and the prior downhill owner trims it. In 2017, 16 years later, the plaintiff brings an action under the San Francisco Tree Dispute Resolution Ordinance. Case does not settle. Lawsuit is filed in Superior Court based on the ordinance's rights to restore a view lost to tree growth. The ordinance does not have a statute of limitations in it. The downhill owner defends the case by saying there's a 3-year statute of limitation. The uphill plaintiff knew about this way more than 3 years ago, and therefore it should be dismissed. Trial to the court, not a jury. The court visits the site and weighs the benefit and burden. The benefit, according to the court, is the uphill owner's request for unobstructed views of the San Francisco Bay, Golden Gate Bridge, Angel Island, and Marin County, whereas the tree does provide privacy to the downhill owner, but that is minimal. And regarding the statute of limitations, here's what the trial court rules. If this was a permanent nuisance, which continues indefinitely, the statute is 3 years and runs from when the nuisance was created. But, says the trial court, here we have a continuing nuisance that may be discontinued at any time. So, as a continuing nuisance, there is no statute of limitations. Plaintiff wins. Defendant has to remove the tree and cut it down to grade level. Plus, the court awards costs and fees and sanctions under 128.5, a total of almost $160,000. Downhill owner must really want that tree. They appeal. The Court of Appeal affirms. This is a continuous nuisance. It is an unintentional and it is abatable because you can cut the tree down. It is not the continuing actions of the defendant. It is the continuing damage because the tree is there and it continuously blocks views. The tree can be trimmed so it is abatable, and the common law rules apply. No statute of limitations is applicable. Why didn't the Court of Appeal order the tree trimmed? Because the trial court exercised its discretion and said, these people have been fighting so long and so hard over 7 years that as soon as they trim the tree, it's going to grow back and it'll be back in the same place. Therefore, says the trial court, we want the tree removed. Court of Appeal affirms. What's the lesson of con versus price? If you're an owner and want to restore a view, check your CC&Rs. Many CC&Rs guarantee a view and call for removing obstructions. Check your local ordinances, like the San Francisco Tree Dispute Resolution Ordinance, and see if the CC&Rs or these ordinances apply that might give you additional rights. Next slide. Chase versus Wismen. Noise nuisance. This is a case involving two adjacent property owners in the Hollywood Hills, the Mount Olympus subdivision. The two adjacent owners are plaintiff and defendant, along with Mount Management as an additional defendant. The facts of the case are regarding noise. The defendants added equipment, pool equipment, air conditioning equipment, and they put that equipment at the property line at a retaining wall to amplify the noise and directly under the bedroom window of the plaintiff. The machines are said to run constantly. Plaintiff alleges it is like sitting under a jet engine, unbearable for hours. Plaintiff measures the noise at 65 to 73 decibels in violation of the LA Municipal Code, limiting noise to 45 to 55 decibels. Trial court enters a temporary restraining order, then a preliminary injunction, then a permanent injunction, ordering the defendants with all the machines to relocate the equipment to another side of the lot. The plaintiffs are seniors with quality of life issues, and these are very important problems to be resolved. If there's money involved for relocating the equipment, that can be determined later, who gets what. Court of Appeal, affirm. On appeal, the owners said, we don't always violate the noise ordinance, only some of the time. Therefore, you cannot enjoin us for when we are not violating. Court of Appeal said, you lose. The noise ordinance has a catch-all provision. It prohibits any noise of any amount that disturbs the peace or causes discomfort, so that all of the acts complained of by the plaintiff can be a nuisance despite the decibel limits if they interfere with use and enjoyment of the property. Here, there is substantial evidence that these noise issues do disturb the peace. And therefore, even though the noise is within the municipal code for at least part of the time, it can be enjoined by the court. If the municipal code said, these are the limits and anything under this cannot ever be enjoined, that would be a different story. But it doesn't say that. Once again, just like a block view, check your CC&Rs, check your local ordinances. Find out what those limits might be. They may give you some protection so you don't have to go to the Court of Appeal. Next slide. Protect our neighborhoods versus City of Palm Springs. This is another case in a long series of cases fighting about short-term rentals, Airbnb, VRBO, weekend rentals, generally less than a month. Are they allowed? Are they a problem? What to do? This case concerns the City of Palm Springs And in an ordinance in 2008, it's expressly allowed short-term rentals at single-family residences. In 2017, they reapproved the short-term rental ordinance. The plaintiff, Protect Our Neighborhoods, filed a lawsuit. And in short, they argued that a short-term rental of a single-family home is a commercial use, and that in residential zoning, commercial uses are not allowed. They were supported, the plaintiff, in this argument by a recent case from Carmel by the Sea, which held exactly that short-term rentals are commercial and should not be allowed in residential zoning. But Palm Springs is different. And here, the trial court upheld the ordinance and the Court of Appeal affirmed, because the ordinance applies to not just residential uses, but uses customarily incident to single-family residences. And R1 zoning in Palm Springs does not prohibit annual or month-to-month rentals or short-term rentals. The ordinance expressly stating in Palm Springs, short-term rentals are merely secondary use and not commercial. And the case from the Carmel by the Sea did not have the customarily incident language and would not be binding on Palm Springs anyway. This is not going away. When you are concerned about short-term rentals, look to your CC&Rs. Look to the operating rules. Look, if you're in Carmel by the Sea, look to the Coastal Commission. They may have a lot of things to say about changing the use of property by the Coastal Commission. So the short-term rental fight goes on, and it changes from place to place, and there's no sign of it going away anytime soon. Next slide, Falcon Brands. This case raises the question, when do settlement discussions become extortion? You might say, Mark, extortion's a criminal thing. What's this doing in a homeowner association? What are you talking about? The answer is that in some situations, settlement discussions become extortion. Here is a case that shows one line. Plaintiff Nick Honard sues for wrongful termination. He wants wages of $490,000 from Falcon Brands, his employer, which is a cannabis company. So the attorney for Nick Honard wants the $490,000 and says, if you don't pay, we're going to disclose the unpaid wages to your proposed merger partner, the proposed merger of Falcon Brands and Coastal Harvest. And not only that, we are going to tell Coastal Harvest about other illegal activities by Falcon Brands. If you don't pay Honard, we're going to tell Coastal Harvest all about your violations of the Bureau of Cannabis Control Regulations. And we're going to even tell Coastal Harvest about your bribing a deputy district attorney about a driver caught driving marijuana across state lines. Here's the problem. The lawsuit filed in court does not mention those illegal acts or bribery. It only talks about unpaid wages. So by expanding the threats of disclosure beyond wages in the complaint, it creates the problem. The attorney for the plaintiff says, wait. We never threatened to go to criminal prosecution. We never said we were going to repeat anything to the media or any authorities. All we said we're going to do is to tell your merger partner, Coastal Harvest. And under Civil Code 47B, all settlement discussions are absolutely privileged. So you couldn't tell anybody anything about our settlement discussions. So the plaintiff, when the defendant filed a cross complaint for extortion, the plaintiff moved to throw that out, saying anti-SLAPP is claims against, which are strategic lawsuits against public participation, that these are in the litigation format, they're confidential settlement discussions, they cannot be the basis of any type of a lawsuit. Trial court, plaintiff wins, anti-SLAPP granted, not extortion. All you're doing is telling wage and other claims to a proposed merger partner. That's not extortion, says the trial court. Says the Court of Appeal, reversed. It can be extortion. Why? The lawsuit filed in court is for unpaid wages, not alleged criminal acts. But the threat to disclose alleged criminal acts in a lawsuit about lost wages transforms legitimate wage claims into extortion. Extortion is defined by the Court of Appeal as the threat to disclose criminal activity entirely unrelated to the damage claims in court. It's the threat to reveal damaging information, not the actual revelation. Okay, so you didn't tell the DA, you didn't tell the paper, you didn't tell the media, but you threatened that you would reveal that information when it had nothing to do with your lawsuit if they weren't paid money for lost wages. That is extortion. It is not protected by anti-SLAPP. It is not legitimate settlement discussions. And let me tell you, the unpaid wage claim just got completely changed around. Completely. Look at the fourth bullet point. The defendant Falcon that employed Honard says, as a result of the disclosure of the unpaid wages and the alleged criminal activity, the proposed merger partner, Coastal Harvest, canceled the deal and demanded return of more than $51 million already paid to Falcon Brands. Because of an alleged extortion, it's a different case. Next slide, please. Now we are going to talk about verdicts and settlements in the trial courts. Everything before was from the courts of appeal. The first one we're going to talk about is a $38.9 million jury verdict. Let me ask you this question. Do you have people that annoy you? Do you have board members that won't see things your way? This is the legal panel. Do you have associates in your office or opposing counsel who are just a pain to be with? What about this idea? Why don't you create some fake internet stuff about them? So maybe they'll go away. This is what happened when they tried that in Dallas Gunderson versus Edward Jones and Company. Bottom line, don't even think about doing that. Dallas Jones is a stockbroker. He works at the Edward Jones office in Willows, California. This is not a runaway jury in LA or San Francisco. This is Willows. Plaintiff works at Edward Jones, managing $130 million for his clients. The plaintiff is terminated for alleged improprieties. The remaining people in his office, some of them decide they would like to get his book of business so that it stays in the firm and goes to them. The first thing they have to do is to get rid of plaintiff's cell phone. So, according to the summary of the settlement of jury verdict, the defendants weaponized Craigslist, created fake Craigslist ads so the plaintiff's telephone would be inundated with phone calls for all sorts of crazy things, and the plaintiff would be required to change his mobile phone number. Now his clients can't reach him, he says. Also, plaintiff alleges the remaining people in the office, some of them used defamatory statements to plaintiff's former clients, so they would worry about the security of their funds. You might say, well, the plaintiff must have proved all kinds of lost income and damages, and lost commissions and all that. According to the jury verdict summary, the only damages discussed were for emotional distress. The summary of the jury verdict did not mention lost clients or lost wages. So what do the defendants say about only emotional distress? What do the defendants say about this? The defendants were criticized in some publications about not taking the claim seriously. They alleged that all the statements about threats to the accounts and things were true. And the defendant who posted the fake Craigslist ads to inundate the cell phone number, why, that was just a prank. As though they were perpetuating the attack. The jury awarded $39 million in damages, including monetary damages and punitive damages. Let's talk about punitive damages. You got insurance for punitive damages? You can't do it. It's general rule. There are exceptions, maybe. General rule, you can't insure punitive damages. Well, they'll just declare bankruptcy. Wait, punitive damages are usually an intentional act. You might not be able to declare bankruptcy for an intentional act. This is huge. This was way beyond expectations of both sides. The amounts they were talking in settlement, according to the summary of the jury verdict, defendant Edward Jones made no settlement offer pre-trial. Really? And the defendant who created the fake Craigslist ads offered 150 grand. That's 1/2 of 1% of the jury verdict. That's a settlement offer? Really unusual. You have people that annoy you? Everybody does. You want to do fake Craigslist ads? Don't even think about it. Right-hand side, same slide. $32 million, LA Superior Court, Smith versus State of California, Caltrans in LA County. Bus accident at a crosswalk in Redondo Beach. 13-year-old bike rider rides her bicycle southbound next to Pacific Coast Highway. She winds up in a lane by Pacific Coast Highway, hit by a bus and killed. There's all sorts of theories about whether the bus driver was negligent, whether the crosswalk was faded and improperly maintained, whether the crosswalk, the curb cut was in the right direction, all that back and forth. And the jury said all that was. Here's something really interesting about this case. The police traffic collision report at the scene said the accident was 100% the fault of the bike rider who didn't watch where she was going. What did the jury give the bike rider for comparative negligence? 0. The jury gave all the negligence to the defendants. By the way, there were 2 settlements before trial even started, Caltrans and the city of Redondo Beach. The trial went against the bus company. But here is the point. $32 million? Well, maybe it had to do with all of the victims, the plaintiffs, all the people she had to support, all of her, all the things that she had to take care of in life. For a 13-year-old? Well, maybe it was her future income potential. She must have had lots of degrees and a huge paying job. That's how you normally calculate loss of life. A 13-year-old, no. And okay, there was a dispute about whether the 13-year-old was negligent. Okay, she was found 0. But why 32 million? There's no explanation in the summary how the jury reached. By the way, the verdict was only 21.6 million. But the plaintiff's attorney, and the lawyers know about this, had 998 offers. And the verdict went way beyond the 998 offers. That added recovery to the plaintiff. Interest and costs brought the total recovery to 32 million, and the interest is still ongoing. A record for the death of a minor. So here's the question. Does your homeowner association maintain roads, sidewalks, curb cuts, crosswalks? Does your association have 13-year-olds riding their bicycles around? What if your association was found negligent in maintaining any of those things? Or even a swimming pool. This isn't a swimming pool case, but same idea. 13-year-old with no employment that we know of, no dependents that we know of, a $21 million verdict, really? Sounds like you better have a talk with your insurance broker. Anybody in a board of directors that maintains swimming pools or roadways or crosswalks or sidewalks, my thought would be talk to your insurance broker. I'll bet you were told to have at least 10 million in liability, if not double that. Next slide. More trial court verdicts and settlements, 12,622,000. Jury verdict, LA Superior, Louis Acosta versus MAS Realty. The plaintiff is a lighting technician employed by a lighting company, sent for a roof inspection on a Riverside strip mall owned by the defendant. The mall manager knows about a missing spring in a roof hatch door, so that it is heavy and dangerous to operate. The plaintiff goes up on the roof. As the plaintiff is exiting back down the roof, the roof hatch door falls on the plaintiff and injures the back. 2 spinal fusion surgeries, more spine and shoulder surgeries needed. The mall owner blames the plaintiff, roof inspector, and the light inspector and the employer. Plaintiff admits He saw a broken spring when he went up on the roof, and he saw a hand note saying hatch broken. The defendants also argued the defendant could go back to work at a higher pay, so there was no lost future income. Here's the issue: workers' comp. The plaintiff is on the job. Aren't his claims limited to workers' comp? Usually they are, but for an exception. If an owner knows of a concealed condition and fails to warn the employee coming on the job site, that's an exception to workers' comp. So the plaintiff can get workers' comp and still sue the owner. Was the plaintiff fully informed of this danger before being injured? Not according to the jury. The lesson of this case is repair those problems right away. Do not allow a long period of time between when you know of defects and when you fix them. Furthermore, do you have $12 million in liability insurance? I'd suggest you better think about that. We're in a time of inflation. Whatever you have now, you should think about increasing it in terms of liability insurance. Furthermore, do you have workers' comp? What if this roof inspector somehow became your deemed employee? It could happen. We'll talk about it later. Right-hand side, same slide. Ordonez versus Rezamovich. The plaintiffs rent a home built in 1911. After they move in, the daughter is born 1 year later. The daughter has blood lead 10 times the US average. Loss of IQ, speech and language delay, attention deficit hyperactivity disorder, plus water leaks, roach infestation, and a lot of other things you would expect from a property built in 1911, over 100 years ago. Plus failure to disclose. What is the defense? Failure to supervise? A 1-year-old kid? Failure to supervise? And unsanitary habits caused all these injuries to the child? That's not going to work. That's why the defendants settled for $6 million. Here's the question. Do you own or manage property with lead paint? Do you have $6 million worth of insurance? Do you do all the disclosures you're supposed to? Better think it through. Next slide, please. $3.15 million, Ross Hart Mediator, confidential settlement. This is a homeowner association action against a developer for construction defects, water leaks through the building envelope, defects in post-tension cables, soil subgrade, and drainage facilities, damages for costs of repair, investigation, and design of repair procedures. Fairly routine claims and settlement under the Right to Repair Act. Here's the question to put this in for you. Why confidential? Why? Homeowner association has fiduciary duties to its members. That's full disclosure, not confidential. Furthermore, what kind of remedies are there? Let's say the developers allege the homeowner association blabbed and broke confidentiality. Does that mean the developer can sue the association? For how much? I mean, it's unknown. The case could drag on for years. Then you're in litigation for years. Why confidential? Usually, the construction company wants it confidential. Sometimes they even say, we'll pay more if you make it confidential, so nobody else finds out I screwed up here, or something like that, hypothetical. Confidentiality is not a good idea, in my opinion. Right-hand side, another confidential case with even more issues. 1.3 million, plaintiff is performing tree trimming. Do you need a contractor's license to trim trees? It could be you do. The trimming was at defendant's residential property. Of course, a tree branch falls down, causing severe traumatic brain injury. The plaintiff says he's not a licensed contractor, so the defendant owner is presumed negligent. The defendant owner claims the tree trimmer was intoxicated and trespassing. Really? That's your defense? The unlicensed contractor may be presumed as an employee of the owner. Let me say that again. An unlicensed contractor can be presumed as an employee of the owner. Does the owner have workers' comp? Because workers' comp should apply if the assumed employee. According to the summary of the settlement, the case settled for policy limits. Really? 1.3 million insurance on a home? I think that's way too low. Next slide. Left side, 1.253 million, jury verdict, San Diego Superior. Welsh versus Mission Grove offices. Do you own or manage offices? Do you own or manage residential property with outdoor walkways? Here, the plaintiff is exiting the property and the left leg falls through a rotten deckway surface. Falls through to the knee, all sorts of soft tissue injuries up and down the body, pre-existing conditions. Plaintiff sues the ownership entities, alleges building code violations, dangerous conditions from a failure to maintain and repair the outdoor walkway. The defendants defend by suggesting, I didn't make this up, suggesting the plaintiffs cut a hole in the walkway and faked the injury, and that it's unreasonable for the defendants to inspect the walkways of their office park because they're 70,000 square feet. That's not going to fly. If you have an office park, even if it's 70,000 square feet, you have to inspect and repair. Soft tissue injuries only with pre-existing conditions. The law is eggshell plaintiff. You take your plaintiff like you find him. You can't get rid of liability by saying the plaintiff was prone to injury. The defendants also argued that no effort to return to work in 5 years, so there's no lost income. What did the jury say? The jury rejected all of that defense. They said past and future medical costs, nothing in there about reduction for pre-existing conditions, pain and suffering, and lost earning capacity. So here's the question. Do you inspect and repair your common area frequently and quickly? Do you have $1.3 million in liability insurance? I'm suggesting 10 million. Ask your broker. I'm not an insurance expert broker. Right-hand side, 1.15 million settlement, LA Superior, Espana and Granados versus 523 South Westmoreland. This is another uninhabitable case. Plaintiffs are tenants, 56-unit apartment building, owned and managed by the defendants. Plaintiffs allege swarming with vermin, bed bugs, roaches, water leaks, mold, and sewage floods, rendering the apartments uninhabitable. Alleged negligence, nuisance, emotional distress, breach of warranty of habitability, violations of the Civil Code, Business or Professions Code, bodily injury, emotional distress, and lost personal property for 6 years. No mention of a statute of limitations defense. Class action, didn't say so. The past apartment owner, previous to the current owner, paid $150,000. Current owner pays policy limits of $1 million. That's what it said. I'm not making this up. A 56-unit apartment building has $1 million in policy limits. Huh. They're lucked out. Next slide. $860,000 settlement, Ross Hart Mediator, San Diego Superior, another confidential case, homeowners versus general contractor. We know this is a homeowner association because the case is brought under Civil Code 895. That's the Right to Repair Act. So they go for right to repair damages, crawl spaces not ventilated, mold and musty odors, water leaks through defects in windows and roof membrane, plus cracked stucco and drywall. It's not a real unusual type of case, but I got to ask you, why is it confidential? The board has a duty, fiduciary duty to its members, full disclosure. And once again, the general contractor is going to hear about this case from somebody else and blame one of the homeowners. And what are the damages? 3 years of litigation? Maybe that's a D&O policy defense, but maybe it's not even covered by a D&O policy for that kind of, I talked about a settlement I wasn't supposed to disclose. I just don't know why it should be, maybe they were offered a bunch of money if they agreed to confidentiality. It still doesn't make a lot of sense. Right-hand bubble, same slide. $76,000 settlement, Santa Clara Superior Court, Wiedemann versus Sunrise Credit. This is another case about a collection action. This is a class action suit. Consumer debt owed to the Bank of America, which allegedly failed to provide a required statutory notice, consumer collection notice, and failed to use the right size of type in the notice. Really? Type size? Violating the collection statute is going to, I mean, you can't deny what the type size is. You can't deny whether or not the notice was given. The longer it goes on, the more you're going to pay in attorney's fees. So usually these cases settle quick and for big money. And what about the debt owed by the consumers? No mention of that. Beginning this year, we have new problems on consumer collections. We are very lucky today to have with us attorney Tom Fear, who represents collection agencies. What about these new laws? Do they apply to attorneys? Do they have to be licensed collectors now? What about property managers? Do they have to be licensed collectors? There's federal law, there's state law. Tom, help. What do we got to do?
Okay, Mark. Effective on the first of the year, January 1, 2022, there came into existence a new law called the Debt Collection Licensing Law. It can be found in the Financial Code 100,000. Okay, it's under the jurisdiction of the Department of Finance, Protection, and Innovation. Kind of a strange name for a governmental agency, but at any rate, there's been a lot of controversy. This law is brand new. There's debates about what is a debt. In other words, as it applies to a homeowners association, are homeowner assessments a debt under both federal and state law? The opinion amongst attorneys who say that assessments are a debt, I would say that's probably the prevailing view. There are some, however, who claim that assessments are not a debt covered under the Fair Debt Collection Practices Act and the Rosenthal Act, which is California, that basically copies the federal act. So the first thing to determine is whether or not it's a debt. The next thing is determine whether you are a debt collector and need to be licensed under this law. And by the way, the law allowed you to submit an application and a license would be granted as of January 1, 2022, but you had to begin this process months beforehand to become licensed. So now, if it's determined that you need a license, you need to start the application process, which is going to take a lot of time. So the next step is, who needs a license under this debt collection licensing law? And by the way, if it is determined that you need to be licensed, there are various notices that have to be complied with. We're not going to get into that, but you need to remember that if you are licensed and there's any communications, just like there's communications to consumers, delinquent homeowners, they owe money, you need to have these proper notices in your communications with them. Okay, who needs to be licensed? Does an HOA need to be licensed? The answer to that one is no. Under federal law, they're considered to be an original debtor. In other words, the debt originated in the homeowners association. ABC homeowner owes a couple months assessments. The HOA is the original debtor. If the HOA uses a third party, attorney, management company, kind of a debt collection assessment agency, those people are not original debtors. So HOAs need to be, HOAs do not need to be licensed. They're not considered debt collectors. What about management companies? So there's some feeling that if an HOA doesn't need to be licensed and a management company is an agent for the association, they don't need to be licensed at all. That's one view. The other view is that management companies send out reminders to people that they're late. They send out late notices. They may even go to small claims court. That may lead to foreclosure. So the question there is, should they be licensed? The federal law, state law talks about, does an entity, debt collector, regularly engage in debt collection? Obviously, let's look at a management company. Management companies, I would say, for the management companies that I'm aware of, debt collection is a minor part of what they do. Do they regularly collect it? Who knows? The law is too new. However, should an attorney be licensed? Okay. In California, they're exempt from being called a debt collector. However, now we've got this new law. So under the California interpretation, the answer is no. Under federal law, this is the Fair Debt Collection Practices Act. Does an attorney regularly collect debts. All right, there's two cases. One case, and they look at the revenue that's generated by the attorney or the law firm. What percentage is that of their overall revenue? Okay. One case said 1.3% of the revenue that was derived from debt collection is not sufficient for them to be called a debt collector. There's another case that 4% of the revenue collected, the court, federal court, came to the conclusion that's enough to make them a debt collector. So where does that get us? I mean, there right now, and I've been trying to get an answer from the Department of Finance Protection, is there any regulations that are going to be coming out that, and from my understanding, somebody has asked them whether or not an HOA management company and or attorney, their attorney should be licensed. So I have not gotten a response from them as to whether or not that opinion is forthcoming, but I suspect it probably will. There's supposed to be regulations under this new statute that are supposed to be forthcoming. That hasn't come about yet. One other thing, and I know, Mark, we may be running out of time because we want to allow some time for questions, but if you violate this statute, if a court or something comes to the conclusion that you should be licensed, the commissioner who's in charge of policing this licensing law, he is given broad discretion as to what he can do if you violate it. Besides suspending your license or revoking it, they can ask for a refund, they can ask for restitution, they can ask for disgorgement of any fees involved, damages. But I would say the most important thing to worry about is there may be civil lawsuits. I can see this coming down the road. There already are firms that just go after violations of federal and state law that concerns collecting assessments. Now they've got more power. They can say you should have been licensed. It's negligence per se. We're coming after you. So, word to the wise, this is a minefield. It's a trap for the unwary. I would say when it comes to collecting, make sure you go to somebody who's an expert in this field. There are debt collection agents, delinquent assessment collection agencies, people that specialize in this. Go to them. Go to an attorney who is familiar with this kind of stuff, and be careful. That's it, Mark.
Thank you very much. So let me summarize. The case we just looked at, Liedemann, $76,000 for wrong type size. Huh. And what Tom just said, the entire new law is vague. Nobody knows anything about it. Here's the bottom line as far as I can tell. Always, always use a professional debt collector. If you are a homeowner association, a management company, or an attorney involved with collecting assessments or other debts. Things have gotten worse. Last slide. Right-hand side, Cooper versus Lee, $95,000 settlement, LA Superior Court. The facts are these. Plaintiffs allege exposure to bed bugs, 100 grand. They reported the bed bugs to the defendants, apparently the apartment manager or owner who hired Pest Master Extermination to perform treatment. The plaintiffs went ahead and filed suit for damages for bed bug exposure injuries and injuries from allergic reaction to bed bug treatment. Couple things. Do not think bed bug claims are frivolous. Do not blame the plaintiff for bringing in the bed bugs unless you have overwhelming proof they did that. This case is brought by a specialist in bed bug claims. Believe it or not, there is a specialist plaintiff. What does specialist mean? Why does that matter? They got all the experts. They know all the rules, all the laws. They know everything there is to know about bed bug claims and how to prove it. You think it used to be that you had a special little niche claim. You could never find experts or attorneys that specialized. Anybody got a cell phone while they're watching this? Just Google mybedbuglawyer.com. In 5 seconds, you can find a specialist in that field, whether it involves homes, apartments, hotels, dormitories. The world has changed. These are very serious claims. And see, 95,000, I've seen other cases with that same law firm. That's cheap. They got off cheap. Take this very seriously. Last bubble, left side of this slide. Rezamovich versus 726 Hudson Avenue. Defense verdict, summary judgment for the apartments. Plaintiff is an apartment tenant. Got himself locked out of the unit. So what does he do? Walks up to the roof to lower himself from the roof onto the apartment balcony. What does he do? Falls to the ground. What does he do? Sues the apartment owner and manager, claiming unsafe property conditions, that his roof access and fall were foreseeable. So the owner and manager should have required a guardrail and warning signs. What did the defendants say? That this entire incident was unforeseeable. We don't need guardrails and warning signs, and it wouldn't have mattered anyway to this plaintiff. And the plaintiff caused his own injury. The court entered a summary judgment for the defense, throwing the case out of court, except plaintiff says he's going to appeal. What does this case tell you as a board member or manager or attorney? What would be the value of this? The case doesn't talk about injuries. It doesn't say what happened to him. It doesn't say the amount or of permanent damage, temporary damage. It doesn't say anything. But assume it's going to be severe. Okay. What this case says is expect the unexpected and make sure you have plenty of liability insurance for the unexpected things that might happen to you. And so that summarizes the last 6 months from the courts of appeal, trial court verdicts and settlements. I hope you have enjoyed the program. I have enjoyed presenting it to you. Thank you.